He picked up a new case. Let that sink in for a second. This guy was already under a no-driving order from a previous offense, and now he's back in front of the judge for racing on a highway. The judge isn't even trying to hide her disbelief. Let's see how badly this backfires.
You picked up a new case. You picked up a new case.
So,
Tell me there was a no driving affidavit in place. He's charged with failure to stop and give information, and now he's picked up a racing case. Tell me that we had ordered him not to drive.
Yes, Judge, on the previous case, there wasn't a driving affidavit.
You promised me that you weren't going to drive. Mr. Gonzalez, now you've picked up a racing on a highway. You are facing up to 6 months in jail and or a $2,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. Officers observed two vehicles accelerating at a high rate of speed from 70 miles per hour to 85 miles per hour in an attempt to outgain each other. The officer initiated a traffic stop on the defendant's vehicle. When the officer told the defendant that he was being stopped for racing, the defendant responded, "Yes, sir." And the defendant told the officer that he did not have a valid license or registration.
Is there a co-defendant?
There is not any co-defendants charged.
Vic, can I see that, please? I'm printing something out.
And here it is, the consequence for breaking a direct court order. Not only is he going to jail, but the judge is filing an entirely separate contempt case against him. 180 days, day for day, no early release if the court proves he was driving. This is what happens when you give your word to a judge and then break it.
What is that? What did you promise me you were not going to do? Guess what happens now, Mr. Gonzalez? Guess what happens now? Did you say nothing?
I'm not sure.
Not only am I putting you in jail now, but I'm going to make your bonds high. And now you are looking at a contempt charge of 180 days in jail. And we are going to have a hearing as to whether I'm going to hold you in contempt. So now I'm going to file a third case on you. And you are now looking, if they prove to me that you're driving in this case, you're looking at 180 days in jail, flat, day for day. Do you understand?
So,
Goes with you. I'm sorry, Sonia, but I'm setting the bonds at each at 10,000 and 2 each. Two, 5, 3, 9, 9, 8, 0. He will auto-populate on tomorrow's docket, and then we'll just go through the rigmarole. I don't know.
He's going to be able to pay that. He's a high school senior.
It's a damn shame.
I don't know what his parents' financial situation is. I'll talk to him and find out.
Talk to the parents.
And that's the moment the bond amount jumps even higher, partially because the judge notices what he's wearing. A designer shirt that probably cost a couple $100s. The implication is clear. If you can afford that, the bond isn't unreasonable. Sometimes courtroom decisions are shaped by details you wouldn't expect.
And then, I mean, I don't know what to tell you, you know, I need to I need to make sure he understands it and that he gets it, but you swore to me you weren't gonna drive and now you're racing? Unacceptable, you know?
Now, this is a genuinely fascinating mix-up. Destiny Collins gets a warrant for missing court, except she has proof on her phone that her actual court date was today, not the date everyone thought. The judge does real detective work here, comparing bond paperwork timestamps line by line, and realizes the mistake was on the system's end, not hers. Drop a mobile phone if you think that phone's screenshot just saved her from sitting in jail unfairly.
I'm gonna make it higher. He was wearing an Armani shirt. He was probably wearing a $200 to $300 shirt right now. 15,002 on both.
Okay, Your Honor.
And then we'll see tomorrow. We'll populate tomorrow. We'll talk again tomorrow. Reach out to the family and you know, perhaps they'll come here and they can see how he is and he can see that we mean business now, you know? Okay, thank you so much, Sonia.
Judge, you're revoking the
We issued a warrant for your arrest because you failed to appear for court, ma'am.
The paperwork, I told him the same paperwork he said I was supposed to appear today. If that's the case, my bail bond company should have told me the same thing, but my court date was for today.
You were ordered to appear 11/22 of 24.
I got out of jail that day. I was released from jail on Wednesday of this week, last week that just passed. So there was no way possible. I could have made it to court that same day. I got released from jail again. And I didn't get released from jail till Wednesday at like 1 o'clock in the afternoon. And then also I have the picture. I didn't bring the physical copy because I forgot it, but the paperwork that they gave me when I was leaving, that said my conditions. I have the picture in my phone with my name on it. It says today at 8:30 in the morning. So I showed up today. If that was the case, I would have showed up when I was supposed to come to court. So I don't get that. And I just sat in jail for a week and a half. I cannot go back.
You issued the warrant on the 22nd, right? This is Miss Collins. She's not on docket today.
what's the case number?
252-6615.
Can I show you the same picture?
She was on the docket on the 20th. She was supposed to be here on the 20th, correct?
The bond paperwork shows, let's see.
I'm confused. I'm confused.
It's not open.
Can I grab my phone and show you my
Don't
picture?
talk to the prosecutor, please. You're not allowed to. I'm trying to figure out what's going on. Because if there's a problem and it's not your fault, I will reinstate your bond.
Judge, so on 11/20, she failed to appear. Defendant not present in holdover is what Jamae wrote on the reset. So she wasn't brought up on the 20th. So she rolled it to the 21st, and then the surety bond was posted. The surety bond says 11/20. So it seems to contradict itself. The 20th,
So whoever wrote the bond did a mistake because they put
whoever hand wrote 11/20
back in time as opposed to, so what, you said you have paperwork that says that you're supposed to be here today?
I left the physical paperwork at home, but I had my brother send me a picture because I forgot it. I can show it.
Yeah, sure. And you can give it to Deputy and she'll. You see that it shows today's date?
Yes, Judge. November 26th at 8:30
Okay,
a.m.
all right. Yep, you're right. Okay, I'll reinstate your bond. Okay. So it looks like while you were in custody, they appointed you a lawyer. I don't know that Martin even knows. I mean, there's no way he's gonna know.
Especially if she's not on docket today.
Right.
Maybe, no?
Oh, I have his number. I'll call him. Let me see. Martin.
Yes, Judge.
Hey, how are you? I have a Miss Destiny Collins that's on docket today.
And now the actual assault case comes into focus. A bar fight where she's accused of throwing the first punches, but then things spiral completely out of control. A crowd surrounds the original victim and starts stomping and kicking her while she's already on the ground, fighting for 2 full minutes. This isn't just a bar fight anymore, it's a mob situation, and somehow it only stopped because someone yelled that police were coming.
Are you in the building? So you were appointed, it looks like, while she was in custody. Say it again? She was in custody in Fort Bend. Huh. Okay. Do you want to stay on the case or do you want me to appoint someone else? Hey, okay, no problem. You just tell me. So that's it? Done. We'll do it. Okay. Okay. Bye. Can you pull up her NCIC, please? So we can... I'm going to take Martin off
Okay.
because he's not working with us. And do you mind appointing someone else for the time being, please? Ms. Collins, you're charged with assault, bodily injury. You're facing a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
On August 8th, 2024, a deputy was dispatched to a bar and grill in Harris County, Texas regarding an assault. The complainant worked at the bar as a bartender. Defendant came behind the bar and began striking the complainant multiple times with a closed fist to the face and upper extremities, causing pain. The complainant began to fight back to defend herself. During the fight, a crowd of people surrounded her, and some individuals who she did not know began to stomp and kick on her while she was fighting on the ground. Complainant
Stop and kick the complaining witness.
That's not true.
Stop, please.
Yes, the complainant stated during the fight a crowd of people surrounded her and began to stomp and kick her while she was fighting on the ground. She stated that the fight lasted approximately 2 minutes. The complainant and the defendant did not know each other and stated that she did not know the defendant well enough to fight her. The complainant stated the fight ended because someone yelled out, "I'm calling the police."
Okay. Tell me, does she have anything else that's open at the time now?
She's currently on probation out of Galveston County for theft.
Yes.
And I think you had mentioned something about Fort Bend, so we're looking for.
Lord, we're hitting the Tri-County area now?
We're not showing anything out of Fort Bend, Judge, but she is on probation out of Galveston right now.
She may have been in custody in Fort Bend. I don't know. So there's not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. I'm going to do everything in my power to protect my public in every single way, shape, form, manner. And if you become a danger to my public, I am first off going to put you in jail.
And here's the part that should worry her the most. She's already on felony probation out of Galveston County. The judge lays out the reality bluntly. When you're on felony probation, you're supposed to be extra careful because picking up a brand new case like this can trigger a motion to revoke. One bar fight just put her existing probation at serious risk on top of this brand new charge.
Next up, I'm going to make your bond so high you're going to flip. Do you understand? Do not go back to this bar or any other bar. I'm prohibiting you from going to any establishment where 51% or more are beer, liquor, any kind of clubs. You're not to go anywhere of this nature. Do you understand? Does she have a felony theft or does she have a misdemeanor theft? And then what else is open? What kind of criminal history we're talking?
Felony theft, Judge. And I believe that's her only history. And Alex is looking into the Fort Bend case as well.
Your Honor, I don't have any record of her case in Fort Bend. Looking at the county clerk website for Fort Bend, I don't see any cases open with her name and date of birth.
So the only other thing you see is it a probation that she's on?
Yes.
For Galveston.
Oof.
Yes, Judge.
Yes, Judge, 2 years deferred on Galveston.
How old are you, ma'am?
23.
What do you do for a living?
Right now, I work 2 jobs and I live alone. I live in the Fort Bend County area.
How much money do you make a month, ma'am?
My monthly income, I say my intake probably about 3,800.
I need you to fill out an application because I don't know if you're going to qualify for an appointed lawyer, ma'am. And I'll take a look at the application. The only thing I'm going to tell you is that when you're on felony probation, you're supposed to be extra special good. And when you're not, they usually file motions to revoke. So I would be on the lookout because if you're on probation or parole at this time, it's very possible that they issue a felony warrant in that case with the fact that you picked up this new case. So understand, no alcohol, no drugs. Do you understand? Okay, do you mind giving an application, please? All right, I'm gonna have you fill out the application and then we'll, do not leave until you sign all our bond conditions, ma'am.